I'd like to introduce our moderator for today. Andrea Katz is a tenured professor of constitutional law at Washington University School of Law, and she writes on American legal history and presidential power. Professor Katz, I'll turn it over to you.
Okay, thanks so much, Michael. Glad to be here. This is super important. Let me give it some quick introductory remarks, and then I'm going to be this sort of stern timekeeper going forward. And as a reminder, questions from the audience are welcome. So if you have a question, feel free to drop it in the chat, and we'll try to get to those. Okay, so a couple thoughts from me from a con law point of view. The U.S. Constitution is not working as it was intended to. James Madison thought famously that ambition would counteract ambition and that Congress would be not just the most important check on the president, but also the most dangerous branch of government. Both of those predictions have turned out, from the viewpoint of 2026, to be flat wrong. So now what? This means that in practice, our separation of powers system operates a lot like a parliamentary democracy, where the executive dominates the legislature when there's conditions of party unification. It also means that in a lot of areas of the law, what the law is depends on at least two other constitutional checks that we're going to talk about today, namely the judiciary and the public. So for several decades now, with the gradual eclipse of Congress, courts are proving to be one of the main lines of defense against the government. Lately, very potently, when it comes to the second Trump administration, in areas including spending, immigration, speech, and others. The public acts as a check in a different way. But vitally, I think we can say on items, big ticket, let's say, items of policy. So for example, when it comes to President Trump's most extreme assertions of power, deployment of ICE agents to Minneapolis, unilateral initiation of strikes on Iran, I think we can call this a war at this point. It's been the public that has pushed back most strongly and effectively. And I think, and probably nobody here would have gone into the profession of journalism if they didn't believe this too, but for the public to do this at all, perform this checking function, they must have information. Democracy is impossible without information. And today, with a surfeit of executive action pushing on the boundaries of the law, it's especially important for the public to understand what's going on, what the law is, to form a reaction to, if need be, against public power. Now, it's not easy to write about courts and the law, as everyone knows. Courts are mostly allergic to publicity. They can write in opaque, jargon-filled ways. They operate with processes that are not always transparent, right, internally speaking. So our task here is to sort of talk about ways to make legal affairs journalists work a little bit easier, or if not easier, then at least let's share some best practices. So I'm thrilled to introduce our panelists. We have here today Mark Joseph Stern, senior legal writer for Slate, co-host of the Amicus podcast, and definitely one of the most trusted voices on the Supreme Court in the country. We also have Nate Raymond, who covers the federal judiciary nationally for Reuters, as well as covering courts in Boston, where he's based. Nate previously served as New York courts reporter for Reuters as well, and also worked at the American Lawyer before that. So, all right, thrilled. Let's tee up some questions for our panelists. So first, let's talk about this idea of what it is that a reporter does. There's a lot of information everywhere on the internet, right? How do you think about the task of providing full and complete reporting that goes beyond just simple repetition of press releases, right? Namely, that meets the time-honored journalistic standards of who, what, where, when, and why. More concretely, what onus do you think that a good story has to meet?
Kick that off, I guess. On my end, I think a good story usually, as journalists, you're supposed to be objective, and so you can't really declare who a good guy or bad guy is. I don't think a lot of times, but I think the readers can usually make up their own mind for that. And I think a good story often, and courts are very good for this because it's a versus system. There's usually an someone that a reader might root for in your story with the with with legal process. And I've always liked that there's it's sort of legal journalism sort of comes close to being sort of like a classical narrative story in that way. That there can be a protagonist and antagonist, even if you're not, as a journalist, allowed to say that out loud, because the reader can decide who that is for themselves. Um, yeah, oh, yeah, that, and in terms of covering courts and what makes a good story, I think stakes, the bigger the better, on the civil cases, especially right now when you talk about cases involving the federal government. I cover a lot of cases right now where I have lawsuits where groups or state attorneys general are asking for injunctions, blocking, various aspects of the administration's deportation agenda, or its rollback of vaccine policies, or halting of spending, for causes that historically we'd long funded as a government. And so, when you start getting into that, it's very obvious sometimes what to cover. I think otherwise, I think sometimes it's just it when you see it. I've been recently covering there was a college student who was arrested at by customs officials at the Boston airport at Thanksgiving when she was going to Texas, and then was shipped off to Honduras a few days later, and in violation of a court order. And that it's a small individual's case, but it sort of cries out as a narrative, and why people have focused on it as an example, right, of a broader trend. So I think sometimes it's obvious, just as on a gut level, what the story is.
Yeah, totally agree about stakes. And this is something that I'm constantly telling folks who are just starting to write about the law for a general audience, who are maybe pivoting from writing briefs to trying to write about the law for people who don't have JDs. You really have to lay out the stakes early on. There's a little bit of a temptation for us lawyers to think about this stuff as like kind of fun brain puzzles, or like to dive into the legalese and to get our hands dirty with all of the stuff we learn about in law school. Normal people need to learn early on why they should care, and then you can coax them into learning about what habeas corpus means, like the difference between a civil and a criminal case, which I think most Americans don't really intuitively grasp off the bat. Due process, equal protection, all of the stuff that we're writing about so frequently these days. You have to show people why they should care at the beginning, and then I'm really convinced you can get them to spend some time thinking about learning about like these deeper issues. And so I always tell new writers, think about what would make a normal person care about this, because I'm sorry, but we lawyers are not normal people. And sometimes what we think is going to really grab people right off the bat, like this fascinating treatise from 1795 that proves that this justice's like understanding of the original meaning of the Third Amendment was wrong. Like, actually, that's not the centerpiece of your article. The centerpiece is what the stakes are for normal people today. In addition to that, and I think Nate sort of gestured toward this, there's the issue of translation and where our obligations sort of begin and end when it comes to translating legal concepts to the public. And that's very much a part of the stakes question. There's always a debate among my team about just how much you can sort of boil down and simplify legal concepts before you're cutting out nuance that is too important to cut, nuance that really, really does matter. I'm often fighting with my editors who want me to like take out some kind of somewhat complicated explanation of a legal issue where I'm like, it needs to stay. People need to understand. And my editors are saying this should be one sentence, not a paragraph. And this is a very frequent push-pull in every Supreme Court piece, except maybe tariffs, because tariffs were pretty easy. But like most Supreme Court cases, there's just this question of how much can we boil it down for general audiences until we've reached a point where like the translation is turning into simplification, and we need to pull back and trust the readers to go come with us. And then also there's the question of, well, where is your opinion influencing your translation? And this is actually going to be a difference between Nate and me, because for us at Slate, we do what we call argument-based journalism, which is basically we tell you our biases up front. So I think everybody knows like where I'm coming from and what my view is. I try to make it clear so that people can sort of assess whatever bias I'm bringing to the table up top, and they can agree with me or they can disagree with me. But my hope is that I can lay out the facts and the law clearly enough that they will be able to reach their own reasoned conclusion. And I'll just say briefly, like one really important part of that for me is always clearly linking to primary source documents so that anyone can read what I'm writing about and draw their own conclusions. We have a very strict policy at Slate. Any complaint, any motion, certainly any court decision needs to be immediately available to readers. I use Document Cloud. Some people use Scribd, whatever service people prefer. We do not assume that anybody's going to go into Pacer and like shell out the 45 cents or whatever to access this stuff. We want to make it accessible to everybody. And I think that's part of why, to the extent that our work is trusted, that people feel like they can take what we're saying at face value and engage with it and disagree with it honestly and fairly, because we are always telling people, if you want to read this stuff, go out there and read it. And we're like completely open to criticism and debates. And that is something that's just very much changed with web-based journalism, with digital journalism in the last 10 to 15 years. Because of course, you know, the print New York Times couldn't link to Supreme Court opinions they were writing about, but we certainly can. And we always encourage people to go read this stuff for themselves.
Love it. Much fun to hear sort of about the craft of stories from both of you. So newsworthiness has sort of been touched on. Let's pivot a little bit to objectivity, which came up, I think, in both of your answers. But could you say a little bit more? So, you know, in particular, there's a tension I hear between the task of telling a good story for the reader and not obvious, you know, not making the law obfuscatory and tedious to read. You know, the more of that you do, the more you're sort of pushing away from some sort of like flat idea of objectivity. So kind of in a micro way, how do, you know, your publications encourage you to sort of maintain objectivity? How do you personally think about, you know, in terms of as you craft a story?
So it's helpful to talk about maybe the primary type of court case that I think most reporters wind up covering, which is the criminal cases. The U.S. Attorney's Office announces so-and-so has been arrested and charged by an indictment for, you know, embezzling money or, something. You know, I think a large part is making sure that you are attributing those statements to the prosecutors because they are just accusations. I think sometimes that can be not always done effectively. A lot of people use the word allegedly a little too loosely when that doesn't necessarily say who's alleging. So I think you got to be clear about who's alleging what. I think you got to also, in that same vein, make sure to track down the defendant's lawyer and ask them for fair comment. And also, I will say, as a philosophy that I have followed for years now and has done me well, is if I cover someone being indicted, and sometimes it means that I get too many email alerts about what happens with their case going forward, I will keep track of it so I can see if they ever plead guilty and are sentenced. You know, especially, and if it's a high profile case, I'll probably cover that anyway. but I more importantly care if they're going to be acquitted, if charges are going to be dropped, um, or anything, or if there's a deferred prosecution agreement or something favorable for the defense, because I think, you got to be aware that we do live in the internet age, and the accusations are very loud on the internet when the U.S. Attorney's Office makes them. Uh, and the acquittals don't get nearly that same volume. And I think it's, as a matter of fairness, I think it's a long-term objectivity in some ways, but I think that's something that I've sort of taken as value. And I take that same view with civil cases. If I cover a case being filed, I think I should, if it gets dismissed, I should write about that too. And it's not the same day objectivity, but I think it's a good thing to have as a rule of thumb.
Yeah, I think Nate does more coverage of criminal cases in trial courts than I do, but certainly that's like undoubtedly best practice. I'll just throw in, there are a lot of situations in which a court, especially a federal appeals court, is reciting the facts of a case, but because of the posture, has to recite the facts in like the best light of the movement. This happens in a lot of qualified immunity cases where the appeals court is taking the facts as true to make the assessment about qualified immunity, and it's really easy for that to get lost. And so there may be some really eye-popping allegations in there, and that the Court of Appeals is sort of reciting them as true because in that posture, the court is like assuming the facts are true to make that particular judgment. And this is something that junior reporters often get caught up with, especially for these super high profile or really kind of shocking qualified immunity cases, that I think all of us need to keep in mind. Like, the reader needs to be told, usually multiple times, like, these are the facts as alleged, and the court reciting them here doesn't make them true. Like, this is just for the purpose of judging whether a party is going to receive qualified immunity or not. And there are other contexts in which that's really important to remind readers, like, these are the facts as alleged. They are not necessarily true. While I'm on this particular like subtopic, I just want to note a challenge that's arisen in the Trump era, which is that federal agency websites are quite frequently inaccurate in their description of who is currently leading agencies and like who is where on an org chart. So up until this point in my career, if the .gov website said, John Doe is leading this particular agency, John Doe was leading that agency. Like, you didn't really have to worry that that information was accurate. For whatever reason, I'm not going to speculate here, but that is no longer the case. And I have had situations where the .gov website will say that this person is leading the agency. I do some research. They aren't. I've had one instance in which the .gov website said that somebody was leading the agency. I repeated that information. This was relatively early on. That person reached out to me and said, actually, I have quit the agency and I no longer lead it, and I do not agree with what it's doing. And then I go to the website and see that in the time that my piece was published and the time that that person wrote to me, their name and face were taken off the .gov website, so somebody raised a complaint. So it's just like, we're dealing with this issue of not being able to trust DOJ lawyers litigating in district court, sometimes at the Supreme Court. We're also at a point where you can't trust what the federal government is saying about itself. And I think that is like very strange and something we've had to adjust to. On the broader question of objectivity, which I think was sort of the prompt here, I already said, like, we try to make our biases known. I think that there is a temptation to just sort of assume that, like, what a court says when it's purporting to state the facts are the facts. And I think one great example of this is the praying coach case that the Supreme Court heard, where the Supreme Court simply dictated, here are the facts. This coach was punished for privately and quietly praying at the 50-yard line. And we had a real kind of debate in my team about what to do about this, because as the dissent pointed out in that case, it was untrue. It was simply not true what the Supreme Court majority said about the facts of the case. And we decided we were going to just tell readers, here's what the majority said, here's what the dissent said, here's the photographic evidence that the dissent included to show that the majority is incorrect, and simply not relaying the facts truthfully. And I think that is another kind of new challenge. Earlier in my career, we didn't often have situations where you had the dissent accusing the majority in a case of just absolutely misrepresenting the facts. And it presents a challenge for trying to be objective as a journalist, because you've got two competing views. Who do you say is correct? Whose views do you relay? And I think that's another area where just kind of putting your cards on the table can be helpful, to say, look, this is what these judges said. This is what those judges said. I'm going to make a judgment call. I think this side has the better argument. But again, we're going to put the pictures in there. We're going to link to the primary source documents. Anybody who wants to make that decision can do so for themselves, and they're welcome to disagree with me. But at the end of the day, I'm not hiding my opinion, because I just don't think that most people are reading Slate jurisprudence for like a super buttoned up, cautious recitation of what court said. They want to know what our analysis is. They want to know what our assessment is. So that's what we're putting out, and we're trying to do so in as candid a way as possible.
It's fantastic. Picking up on that, I think there's an assumption that if you write about Fed courts, your job is easier than if you're a state court reporter, that there's more like publicity, more access to records, easier to navigate like court databases. Is that true? I guess that I'll refine. Are there moments where you sort of can't rely on sort of what's professed to you, whether it's by an agency or a court's recitation of the facts or a court's statement of charges? So what do you have to do in those cases if you can't quite rely on sort of public-facing information?
So, sort of alluded to a little more trial court oriented, and he's more appellate and Supreme Court oriented. My experience, though, generally is it is easier to cover federal court than state court, because the federal court have a pretty good online system to download records. It is expensive, it is outdated, it is antiquated, but a lot of states don't even have that. And I'm in Massachusetts. Up until the pandemic, I still had to go pull files in hard copy in state court here. And I still actually have to do that in criminal cases. We had a case with a celebrity chef who was charged with groping someone, and I just kept having to pull the files like repeatedly, which is very old school. So in that way, I think the federal courts are easier, just because of that. That said, I think there are practices that vary district by district. I'm in Boston, like I say, and our court has a very nice calendar that is very easy to follow. Other courts, I used to cover the federal court in Manhattan, the Southern District of New York, which is very prominent. Its calendar is a mess, and it is a disaster to follow. Many hearings are not listed on it. And often you just have to know someone to ask what was going on. But generally speaking, just on the mechanics of it, thanks to this outdated PACER system, it's still better than state court in my general experience.
I'll agree with a few footnotes. I mean, just in general, like state equivalents of PACER, when they exist, are so opaque to me. I find myself just reaching out to lawyers and asking them to email me the documents more often than not, and that's not something I need to do with federal courts. So in that sense, absolutely, it's easier. I will say that one challenge that we're experiencing, I'm sure that Nate has dealt with this, is that in certain removal cases in federal district court, the filings are presumptively not available online, but you can go and pull them in person. They're not on PACER. Pull them in person. My colleague, my friend Chris Geidner, who has a Substack called Law Dork, has been trying to get the district court in Minnesota to make these filings publicly available. It's been this real struggle. He has like counsel now representing him. So it's not always easy. And obviously those cases are becoming really hot button and they're very important. But for the most part, yes, those documents are accessible. I will say, and I often say, I could teach a seminar simply on navigating the United States Supreme Court's website. The website has generally the information that you need, not always, but generally, but it is so Byzantine, and the way that opinions and orders and calendar updates and all this stuff, the way that they're all uploaded is so bizarre. I mean, when the Supreme Court announces that opinions will come down on a certain day, what it does is just very, very, very quietly changes on the calendar date on the homepage. If you click on that date, it'll say there's a possibility of opinions, and then you just have to go and like click through to see that opinions are coming down and share it. Opinions are uploaded to 3 different pages on the website, depending on how the court categorizes them, which is fairly random. There's opinions related to orders, and then just orders of the court, which are sometimes include very brief opinions. Nobody knows why. Sometimes they'll be on one page and sometimes on another. It's just a really unfriendly website for the public and for journalists who are trying to break into this. I don't know if it's on purpose or because like it's just really outdated, like Pacer, and they've never put the time and effort into it. But I do spend a fair amount of time like just navigating the Supreme Court website and explaining to people, like, here's how we know who the lawyers are arguing this case. Here's how we know there will be opinions on this particular day. Like I do TV, and bookers are constantly asking me all these questions, like, when are we going to have opinions? Why don't we know when this is coming down? Where is this on the website? And I just have to tell them, like, you will never master this, because unless you have to for professional obligations, it is pretty much impenetrable. And I think that's unfortunate, and I think it could be done better, but that's the way it is. And so that's something that I spend a lot of my time doing.
Fun to get all the sort of disclaimers about the transparency of the federal court system for researching. So a lot of the questions that we got from the audience had to do with how you determine newsworthiness in various flavors of this question. So I think a question that's more aimed at Nate is sort of when you're deciding what hearings to cover, how can you tell what's like going to be an important hearing as opposed to like sort of routine scheduling? And then I think a more Mark version of this question that people asked, what increases the likelihood that a case will make it to the Supreme Court? You know, so somebody mentioned the St. Isidore Catholic Charter School case that the Supreme Court recently deadlocked on, and how quickly that case moved through the courts to the Supreme Court. So just can you talk about why that was and whether that's an anomaly among cases? But maybe first, Nate, with the sort of hearings and generally, you know, what cases are likely to turn out to be newsworthy?
So, you know, there are, in my mind, 2 categories of cases, right? Like the criminal and civil. And on the criminal ones, at the level, you know, the key hearings are ultimately arraignment, plea hearing, trial if they don't plead guilty, trial, and then sentencing. There are going to be status conferences, which are usually check-ins. Those are mostly skippable. If you ever see a status conference, unless if it's a super high profile case, you can probably skip it. And there will be motion hearings, in those cases to maybe, maybe the defense wants to dismiss an indictment or wants evidence suppressed. I think on those, I think it depends on the nature of how high profile the case is and how much of a priority it is for your news organization to cover. There are cases that I track that I will go to every hearing, and then there are ones that I just go to the key ones, like I say, the plea hearing and the sentencing or the trial. And even with the trial, depending on the nature of the case and how high profile it is, I might just wait for the verdict. But I usually try to at least go to the opening statements, and if I don't make it to those, I'll go to the closings to try to really get the flavor of everyone's arguments. At least to inform a verdict story. On the civil side, again, status conferences generally skippable. Anytime you see a status conference, it's usually just a check-in. But sometimes maybe a judge on the docket will say that they're going to raise a particular issue, and if that issue matters to you, then definitely check in. But if there's a motion hearing and it's particularly, with these Trump era cases or even the Biden era case, right? Like, I mean, any case really that where it's challenging a presidential administration of the policies, you're looking for motions for temporary restraining orders, motions for preliminary injunctions, and hearings on summary judgment, which would be, on the merits. Those are key hearings, and the ones that have the most speed are those TRO or preliminary injunction ones. So those are key hearings. And then the federal appeals courts are pretty easy because those ones have just very clear oral argument schedules for when they're going to hear a case. There's not any of these status conferences that I'm complaining about. So those are all, if it's a case that you care about, then those are the hearings to listen to.
So for the Supreme Court, just sort of the basic rules of the road are if a lower court strikes down a federal statute, generally the Supreme Court feels an obligation to take that case. If a lower court blocks an executive branch policy, generally, but not always, if the executive branch appeals to the Supreme Court feels an obligation to take it. Increasingly on the shadow docket, very, very quickly in a matter of weeks, with an interim ruling that is quite often just the last word. Those cases increasingly under Trump just skyrocket to the Supreme Court. And the president has secured many, 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 many favorable rulings in those situations. As a rule, the Supreme Court feels obliged to consider circuit splits, which are issues that have divided the federal courts of appeals and or state Supreme Courts, usually on matters of federal law and specifically constitutional law. So the Fifth Circuit says that the First Amendment means this. The Ninth Circuit says the First Amendment means that. The Supreme Court will usually at some point take up that issue to say, we need to resolve this circuit split so that federal law is consistent throughout the country. Beyond that, it's a little bit more mysterious. The St. Isidore case is a good example of what I would consider to be some members of the Supreme Court trying to sort of pursue what we might cynically call an agenda, or more charitably call like a very particular view of what the law should be and a desire to move it in that direction. So in that instance, the Supreme Court's conservative majority has been pretty doggedly pushing states to expand public funding of education to private religious schools. This has been going on for quite some time. And in a series of cases, the Supreme Court has been telling states under the First Amendment, you have to provide this public funding to private religious schools. You can't limit it to secular schools. And in the St. Isidore case, that was arguably kind of like the next step there, which was, okay, well, does a state have to, under the First Amendment, recognize and fund a Catholic charter school as part of its public school system? I think it seems pretty clear that 4 justices thought the answer was yes. It takes 4 justices' votes to take up a case. That's the so-called rule of 4. But then when it got to the court, it turned out that Justice Barrett had recused herself and the Chief Justice had some hesitation, some misgivings about this. And so the court deadlocked and it turned out to be a waste of time. I do kind of feel for lawyers on both sides of those cases, the deadlock, by the way, because millions of dollars get poured into high profile Supreme Court cases. I mean, a lot of people spent a lot of time and a lot of money just to get no resolution, but that's what happened. And, 4 justices really wanted to take the case, but couldn't find a 5th vote to decide it. And so, when we're talking about what's newsworthy, anything that reaches the Supreme Court is newsworthy. Any case at the Supreme Court that it's taken up is fair game for us to cover. We cover all the big ones. We cover a lot of the medium-sized ones. There was a pretty important case about whether you can sue the government when a mail carrier intentionally destroys or withholds your mail a few weeks ago. I would call that sort of like a medium-sized case that we still thought was important and we covered. With the lower courts, it's always more of a judgment call. I think I would say really major decisions like blocking deportations to El Salvador, that's important. We're probably going to talk about that. We're going to cover it. But some of these other decisions blocking Trump policies, I mean, they come so fast and furious. We're a small team. There are not a lot of people on the jurisprudence team. Like, we can't cover them all. So what we're looking for are cases that seem destined for SCOTUS so that we can kind of get in on the ground floor of coverage, and cases that speak to like a broader trend in the judiciary or a broader thing that's going on right now. You know, a district court judge accusing the administration of violating court orders is a big one for us right now, because as we've seen, that is trend, and it is escalating, if anything, at the moment. The executive branch has been violating many court orders in many different states. So we try to focus on that so that rather than telling the one story of one court that did one thing, we're telling a story about multiple courts that are dealing with a similar issue, and trying to explain what this tells us about the judiciary during Trump's second presidency.
Right. I found that answer fabulously helpful from both of you. Okay, maybe one more question with the time that we have. I think the reporters here all know a lot of law, but we got a lot of questions of how did you learn the law? What maybe more concretely, what resources have you found helpful for understanding federal courts, including resources for how to keep track of lawsuits, follow a docket, track down sources, etc.?
So on my way, and I stumbled into it. I do not have a law degree. Did not go to law school. I actually grew up in Alaska and took a job at the American Lawyer because I needed a job right out of college, and there was a professor at a colleague that worked there. You know, I think a big resource, actually, in my experience for legal journalists is actually other legal journalists. There is no. I've always wished that there was a good class or something that could just teach people. But in experiences, and especially, you know, I'm now in my second decade at this point. I spend a lot of time, you know, if Law 360 brings in a new young cub reporter to Boston, even though I don't work for them, I'll on the side sort of tell them some pointers on, you know, and help them out. And you know, the same with the Boston Globe's veteran court reporter. She has also helped me sometimes on the side, you know, because I think we're all competitors in some way, but we also all aim for the same thing, which is access to the courts and to get information out there. And I think that's a good thing. I also think when courts have been amenable, I think it's been great when judges will talk to reporters off the record or on background, not for leaking or anything like that, but just to like teach reporters the world and how courts work. And you know, when I've taken on court beats, I've usually reached out to some judges and be like, I'm new in town. Could you help me out to understand things here and maybe show me processes and sort of understand, you know, sort of the minutia of like how things get uploaded onto Pacer, or just, you know, is there a better way to find a court calendar? That's insane, not real system that exists, which was my experience in New York. You know, that's some ways. I mean, I will say in my the courts are still very antiquated with technology, but things have been getting better. You know, when I started out, I could not get email alerts as a journalist for court filings, and now I can. And there are these services like Court Listener is a new development, and that has been a huge development. But also at the federal level, a lot of district courts have expanded and allowed a lot of media to get the same sort of email alerts as lawyers. And if you look on your district, you know, depending on what district you're in, you know, that's a great resource to, you know, be on top of things with. So, you know, and it's also just good to befriend some lawyers, even if not as actually. I always have like a lawyer or two. Like I have academics and lawyers for like specialty expertise, but then I have lawyers for dumb questions that I just ask them and that they're good to go to, just not to be quoted, but just I like need someone to just explain to me something really dumb so I don't make a mistake in my story. And that's also always helped.
I know we're right up at time, so I'll just say briefly, totally endorse all of that 100%. I did go to law school. That does not make me an expert in everything. And so I'll just lift up the last thing that Nate said, which is that in my view, the best thing about this job is that you can call up a subject matter expert and just ask them to like teach you about something for a very long time. And they'll do it. I mean, you can call up professors, you can call up practitioners. Most of them are happy to like walk you through. And I just feel like I'm really lucky because I get to learn so much on this job about so many fascinating areas of the law that I wouldn't otherwise touch if I were practicing in a particular area. And I definitely encourage all legal reporters, especially those just starting out, just do it. Just send the email to the professor, send the email to the Supreme Court litigator, say, hey, can we hop on the phone and talk about this? And often they will, and your piece will be better for it, your coverage will be better for it. It's one of the really wonderful perks of this job, and I think everyone should take advantage of it.
That's fantastic. Yes, I'm happy to be called. I wouldn't dream teach any of these people about PACER or court listener or pulling hard files in criminal cases. But if it's a con law question, I'm happy to be asked. Okay, great. So we'll wrap up panel one there. Thank you so much to Nate and Mark. I thought that was super enlightening. All right, so we'll turn to panel two. Thank you guys again.
Thank you.
All right, fantastic. So now we're going to be talking about state court reporters. So we have with us, I'm thrilled to introduce, so we've got Bob Agelko. So Bob has been reporting since 1970, covering the courts full-time since 1984 for various publications, including the Associated Press and now the San Francisco Chronicle. We have with us as well Alexa Schrake, who covers litigation and trials for the Texas Law Book. She is based out of Dallas. She worked previously for the Indiana Lawyer. And finally, we have our host today, Michael Karlik. Michael lives in Denver. He's the judicial reporter for Colorado Politics and the Colorado Springs Gazette. He covers various appellate courts in Colorado, including the Court of Appeals, the 10th Circuit Court, the U.S. District Court for Colorado as well, and the Colorado Supreme Court. Okay. So it matters federal and state. All right, so let's kick us off. State courts handle by far the overwhelming majority of litigation in the country, yet many people seem to not know very much about them. So first of all, how do you make the case to your editors that state court coverage matters, and how do you decide which courts and cases to prioritize?
That's a question, and the position that I'm in right now didn't exist before I started doing it. I was doing breaking news, and that involved looking for anything to cover as frequently as possible. And it just so happened that the things that I was finding that other outlets were not getting to were things like state Supreme Court decisions, 10th Circuit decisions, and I found it really easy with the narratives that judges often present in these opinions to get a sense of what the underlying controversy was, what the relevant facts are, what each side's arguments were, what the law is, and then sometimes why it matters. And so I just started writing more and more of those until I was eventually doing judicial coverage full time. And my editors were okay with me doing it because they were getting feedback from readers who actually did want to see this type of news, people in the legal community and just regular folks who are interested in what the courts are doing. So I do have to kind of self guide the coverage as far as I can't do everything. I can't follow all 350 state trial judges and what they do in their courtrooms every day. So I really focus on the top layer of the state courts, the policymaking level, for lack of a better term, which is the state Supreme Court and the Court of Appeals. And then Colorado is a little bit different than other states in that our state capital is also our largest city and it's also in the largest metro area. So we have both of our federal courts headquartered downtown as well, the 10th Circuit Court of Appeals, as well as the federal trial court. And so in addition to doing casework, as I call it, a lot of the judges and the justices also live either in Denver or in the metro area. So if they're speaking at a legal conference, if they're on rare occasions when they're speaking to regular folks, the public, more often than not, I can get to it fairly quickly, or I can even walk to it. And so I do try to treat my beat, in addition to explaining just the legal goings on, I try to treat it as a political beat, in that I cover judges as political actors whose decisions affect life, liberty, and property. And so that is the mechanism by which I screen the cases that I cover, but also deciding, do I want to show up when a judge is talking to lawyers about trends in civil cases, or maybe a new federal judge who's going to be there for a long time is introducing themselves to lawyers after a year on the job. And more often than not, I show up and I learn about law, in addition to learning about the judges themselves and the internal workings of the courts I cover, which can itself lead to more coverage.
Maybe we can hear from Alexa.
Yeah, similar to Michael, you can't cover the whole state of Texas. Just far too big. So there are certain areas that we pay attention to. Mainly, I'm paying attention to Dallas and Houston state courts. The big court that I have become sort of an expert in lately has been the Texas Business Court, which is newly within its first year. Um, and it's been very, very interesting. And that's something a lot of attorneys and our readers are very interested in, because there is no previous legal precedent since it is a new court. So that has been the one that I've been really paying attention to, and my editors are very interested in. There's not much of a having to make a case for covering state courts for my publication. But we really pay attention to like the bigger cases and the lawyers involved is when we're looking at what court to pay attention to.
Bob? We may have to come back to Bob. We touched on this a little bit, your answers already, Michael.
Yeah,
And hey,
you
Bob.
hear me? Yeah, you
Yes,
can
we
hear me
can
now.
hear you.
Sorry about that. Yeah, I'm sorry you can't see me. That's my lack of tech connection. I've been covering the courts full time since 1984, and I was working for the Associated Press in I guess in San Francisco then, and the issue, the political and legal issue on everyone's mind then was the California Supreme Court, because there were campaigns to remove its leaders, its liberal leaders, including the first woman to ever serve on the court, Chief Justice Rose Bird, because they were overturning death sentences. So that was my focus. California, the state Supreme Court, Colorado is different, no death penalty for one thing, but there was an ongoing political campaign to unseat the liberal majority of the court, and it succeeded in 1986, the first and only time that's happened. Large sums of money were spent on it, and it was my job to cover not just their rulings, but what was being said about them, and maybe what was closer to the truth, because the truth was that the campaign was being funded by large business interests that didn't really care about the death penalty. They cared about the court's rulings expanding the right to sue for torts and for various types of damages. But the whole theme of the campaign was cast 3 votes for the death penalty, remove these 3 justices, and by gosh, the voters did it for the first and only time in California history. Now, in Colorado, my understanding is that number one, there's no death penalty, but number two, the judges who have been voted out of office are all from county courts, district courts. There's never been a Supreme Court justice voted out since the voting started. But our responsibility is covering both the legal and political aspects of the court's actions. And at the time, as I said, there was this campaign to supposedly reinstate the death penalty, but in fact was meant to counter the court's rulings expanding the right to sue for businesses. And I think that's something always to remember. arguments, particularly political arguments, often conceal their true intention, which is to improve your chances in the lower courts. The Colorado courts are structured pretty similarly to California, I guess. The judges here in California run for office when when they are when they're on the ballot, or so they can simply be elected to the court, which is not the case in Colorado. But the retention, the nonpartisan retention elections are the same, and I need to cover them. These days, there's hardly any judicial elections in California because there's relatively little controversy about the judges themselves. The state has become pretty firmly Democratic in majority, and there are almost never any judges removed. A few years ago, a judge was recalled because of a sentence he had given in a sexual abuse case. They mounted a big campaign against him, said he was soft on crime, and sure enough, uh, he was denied retention. But my job day to day is keeping an eye on particularly the higher courts, the state court of appeal, similar to Colorado, and the California Supreme Court, as well as cases of interest in the lower courts. They're called the county courts in Colorado, superior courts for some reason in California. Uh, but that's where it all gets started, and you have to try to keep an eye on the filings. They're available remotely for the most part, and when they're not, you can usually get them. My I guess what I try to do most is keep a roster handy of people who can advise me on issues, mainly law professors, also attorneys. This one knows about housing issues, that one about access to the criminal courts, and various other things. They'll know the legal history. And then, of course, I have to deal with any U.S. Supreme Court actions of interest to our state and to the people. Right now, I'm trying to keep an eye on the Supreme Court case called Calais, in which the court may well and probably will strike down a section of the Voting Rights Act that allows districts to be political districts to be drawn to favor or preserve racial minority status, and this court seems quite likely to overturn that. And my task, as I'm always told by my editor, is what's the impact on our state? How will this affect us? And what districts are going to have to change and things like that. And I suspect that that's probably true elsewhere too. The issues are big nationally. The stories of most interest to the readers are what's the effect on us? And that's the thing you should kind of try to do in advance. Find out which districts are going to change, who's going to have to pay more or get fewer benefits or whatever if the court rules in a certain way. So you're ready. Now, I should say that because I'm in California and the rulings are often issued elsewhere, I got to try to catch up. There's a 3 hour difference between here and the Supreme Court. But in any event, preparing for these things is probably just as significant as actually covering them. The other thing I should mention is our judges are generally quite accessible. We have an annual meeting with the California Chief Justice every December. Just come on into the office and we'll give us some sweets and chat on what's going on. I think that is very valuable, not just the meeting with the Chief Justice, but being able to contact judges, their staffs. The court has a PR, a public information officer, and just to know what they're doing and when. Get the weekly list of cases up for review before the state Supreme Court once a week. Get the calendars for oral argument, which we have just about once a month. to just to keep an eye on these things. You don't even have to write a story necessarily on the oral argument. Sometimes they can just educate you on the issues that are coming up. But I find that you can get insight into their workings and their thinking when you hear how they argue the cases, how they respond to arguments, uh, and it makes coverage of the final decisions, I think, more insightful and just easier
Great.
if you know who's talking and what they mean.
Thank you, Bob. Bob's answer touched on a number of topics that I'd wanted to cover, but let me flip something that he talked about to Alexa and Michael. As we talked about on the first panel, there is a perceived and real asymmetry between information getting at the federal court level and in the state court level. So, Michael, I know that you've worked both with the federal and court level. Alexa, you've worked in different states. Could you all talk a little bit about informational challenges that you have faced in your journalistic careers and how you personally have navigated those?
Sure, I can go first, and I will acknowledge that the answer is going to be different state by state just because of the variety systems that are in place. Colorado does have something called a public access terminal where reporters and potentially anyone can sign up to look at a state court docket. Now, there are several exclusions. You can't look at child neglect cases. There's some criminal cases. I think sexual in nature that are just not able to be displayed. Most of the appellate cases, you can look up the briefs, you can look up any lower court orders or the case history, and that's fine for the most part. Trial courts are really hit and miss. I was at an open records event at the Denver Press Club last year, and someone who formerly worked at a high-level position in a state executive agency, was talking about the nature of getting records. And they said, well, there's the open records process, but you can also just talk to the folks in the agencies who are in charge of responding to these requests, and they might be able to help you out in ways outside of the formal process, in ways that are easier for you and easier for them. They can maybe hone requests for what you're looking for. And it reminded me that, the past 4 or 5 years, whenever I haven't been able to get a filing a brief in an appellate case, I've gone to the clerks of the state Supreme Court and the state Court of Appeals, and they have given me that information subject to the redactions that they do. But it's a very smooth process from my point of view. And I remember when, the state Supreme Court clerk was on vacation, and so I sent my request elsewhere in the office. And the response was, okay, we've got your briefs, we reviewed them, just contact us for payment. And I was like, payment? That's that's not something that I'm used to. Is this a new policy? And so they talked with each other, and then eventually word got back to me that, I've kind of had this informal arrangement with the clerks for a while where they can me what I need, and it's not too much of a burden on them, and we don't have to go through the full open records process. And that wasn't something that everyone else at the office knew, and so they were up to date on that. They did not charge me for those records, but just making contacts with the people who can view information, be it in like an individual trial court in an individual judicial district, or for perhaps the entire judicial branch in a state. I mean, you can get things as a reporter, or sometimes even as a citizen, that you might not be able to get just looking at an open records policy on paper.
If I can just add something to what Michael just said, getting the briefs ahead of an argument, ahead of a ruling, I think it's just extremely helpful because you get an idea, a better idea of what they're arguing for and what positions they're taking and what's at stake in this case. Decide, is it worth your time? Who should you contact and things like that. It places the case in the context of in the broader social context, and I think it's very important, very helpful to have access to both sides' briefs before the case is argued, certainly before it's ruled on. Simply helps me understand better what's going on and what's at stake.
Yeah, so being in different states, it's definitely challenging. In Indiana, it was very much there was this one database, and you could find all the documents in there. If the documents weren't in there, then you would just contact the clerk because they needed to make redactions. So that was super easy. Going to Texas, it was such a challenge because there are so many different, each court has its own database, and I had to really navigate that. A lot of the times, what I'll do is just honestly contact the attorneys if they're not already contacting me, sending me the petitions and whatnot. And that's really helpful to have. If that, isn't working, definitely, like Michael said, having a relationship with the clerks is extremely helpful. And they know so much. Like they're very helpful resources. So having those relationships with the parties and the court staff just makes a huge difference.
That's super helpful. I was going to ask about sort of your sort of best practices because we know how to Google, we know how to go to databases, but some of this sort of like off the record conversation type of thing or knowing who to call, whether it's the attorneys or the clerks. So I'm glad we touched on that. And again, I think folks would be interested in, to the extent that you have sort of more tips for sort of information gathering outside the obvious paths. I think people would be quite interested in that. I was going to ask generally sort of what are your suggestions for good resources for reporters to understand the state courts? So maybe you could sort of touch on that in addition to some of the sort of source building kind of insights that you've been sharing already.
Um,
Hmm. You first.
um, so yeah, one of the resources that I used when I was in Indiana was the National Center for State Courts, just like kind of an overview of like they have really great infographics and whatnot if you're doing any research. That was when I was like very new and learning how to figure out, covering courts. They also have people there that you can just call and they'll explain things to you. So that was extremely helpful for me. The other thing at my publication now is that we really stress is getting coffee, lunch, or dinner or whatever with your sources with law firms, that sort of thing, and it has been extremely helpful for me to do that. And it's all off the record conversations, but that those conversations help with like knowing what cases are they currently like interested in, what are they currently working on, and then building that relationship. When they file a petition, they'll send it to us, and so that has made it so extremely helpful to just keep up with the dockets and everything.
And, one of my frequent sources, as long as know who you're talking to, is advocacy groups. The groups like the ACLU on the left and Liberty Justice Center on the right keep tabs on the courts in different states, including mine. And as long as you put it in the context of the causes they're promoting, uh, I think they can be exceptionally informative about what's coming up, why it's important to one side or another, which is really what I'm trying to write about, not just write a legal history, but say, you folks out there who care about one side or another, whether it's the criminal justice or the right to sue or civil rights in general. Here's what the advocates say that you'll need to know. And generally, there's insights on both sides, and of course, it's up to us to be the intermediaries and the editors, as it were. But I think that it's not just the libraries, and not even just the university and other expert contacts, but the advocates are often very well informed, and as long as you know who you're listening to, uh, they can be a prime source of insights into what we're going to hear from the judges.
I would echo all of that, and I just have one or two more thoughts, which is there are some lawyers who get quoted an awful lot in news articles by journalists, and while they may be well spoken and have interesting things to say, they can't be an expert on all aspects of criminal law and civil law and domestic relations law and federal and state law at the same time. So maybe do a little bit of research into who the lawyers are in your community, what kinds of cases they're filing, establish relationships with them so that in the event that your coverage lands in their specialty area, you can be talking to the most informed person. And the other thing, I believe this came up during the federal courts panel as well. I think everyone on this call, even those with the judicial title before their name, are willing to help and be a resource for something you might be experiencing in your community. Even if we can't answer the question for you or talk about the case with you or its significance for your community, we can help you brainstorm and point you in the right direction. And I think everyone who showed up wanting to talk about this and help you guys out would be willing to do that after this call as well.
Yeah. One point I'd like to make that probably doesn't relate to anything that's been asked so far, but when I write about a ruling and it's, and it's contentious or split or whatever, I usually try to cite not just the judge or justice who wrote it, but who appointed that person. Not because I want to politicize the story so much, as I just want to give the readers an idea of, you voted for Governor XY. Here's what you got. Here's one of the results of that vote. And you might either agree or disagree with the ruling, or think the judge or justice was insightful or not, but at least give them an idea of one of the consequences of their actions and their input to the court. And fortunately, my paper will generally write it. So if I say so and so was appointed by Governor Gavin Newsom, say, or President Trump or whoever, then maybe they'll get a little better idea of the consequences of voting for or against that person, and also maybe a little more insight into the judge or justice and how independent they might be.
That's fascinating, Bob. So I'll just inject very briefly. I teach constitutional law at WashU Law School, and I always, in my con law class, devote at least a day to state constitutionalism because I think students don't study it enough. And I think for one of the reasons that Bob mentioned, which is that many states elect their judges, and this is partly a sort of philosophical choice. This is to say the idea is to keep judges sort of closer to the ground and tied to the voters. So this is to say rulings are part of this cycle of voting and democracy. Sorry, sorry, my dog just heard the doorbell. All right, I do have a question though. The question is, how do you think about larger context when you write? So, Bob is sort of bringing up the idea of democracy and judging. But I'm also thinking about things like politics getting increasingly nationalized and how that affects coverage of state courts and state legal issues. But things like polarized parties, executive power, the internet, AI. So, how do you sort of contextualize the job that you have right now in terms of these larger forces? And I'm specifically curious for Bob as well, like how has the craft of legal affairs journalism changed, and sort of the asks on you? So larger context, democracy, the big picture question.
Yeah. Well, I think it's inherent in any of the larger rulings, particularly from the appellate and Supreme Courts, that this is going to affect not just the parties, but society. And we can give people an idea, not just of its effects, but who's litigating the case. It was filed by John or Jane Doe. Where are the amicus briefs coming from? Are they, where does the Chamber of Commerce and the business associations and the civil rights groups, where do they stand so that you can let people know maybe the context of this? Obviously, call them for comment after a ruling if you can, but even before that, the filings and the background of the case will most often give you an idea of where people stand, what this might mean to readers of various political views when the ruling comes out. I try to put that in there. I try not to make every case a political issue, but try to include potential social effects, the potential effects on the parties. Did the Democrats or Republicans even, file on this or support one side or another? Because not, again, not to trivialize, not to make each case a political football, but to give readers an idea of how it will affect them. And it's a delicate balance because I don't want to just say this is this is like a ball game and there's just winners and losers on each side. There are legal issues that need to be addressed first and foremost. But it's also what matters, I think, to the readers and the public and the people who will eventually decide whether the judges stay in office or what to do about the governor who appointed them. And let's let people know what the broader context is as soon as possible, without making that a substitute for legal issues in the case, the guilt or innocence of a particular person or the sentence they have been subjected to. But try to strike the balance between the legal issues and the social and political effects of it. And if I don't get it right, my editor will certainly tell me, as she's not hesitant to do. But it's something that I try to include in practically everything I write.
And I would say to balance, I do agree that using discretion is important, and there are some
Right
seemingly
now.
small cases. Oh, hey, Judge. We'll talk to you soon. You're on the next panel. That's Judge Kane in Colorado. But I was just saying that there are some small cases that do become, at the state Supreme Court level, they have major policy ramifications for all other cases like it. It can create a headache for the trial courts, and you just don't know what cases are going to blow up like that. Consequently, there are some cases that start with a flashy press conference in front of the courthouse. Maybe it's a major civil rights issue that's being litigated, and it gets quietly dismissed 6 months down the line for failing to state a claim or for jurisdictional issues or whatever it may be. So I would say, approach each case with a grain of salt. Know that it could have implications. It could go nowhere, and you don't want to overhype something unnecessarily at the outset, but you also don't want to minimize something that could have major ramifications. So just, again, balancing your coverage, seeking outside perspectives, and sometimes it'll be readily apparent from the face of the case whether it will be big or not. But I would say keep that in mind as well.
Yeah, I would definitely agree with that as well. I think it's very difficult to, when you first, start writing about a case, to like get in the weeds of something, and just get really lost in it. And having to take a step back and look at how is this going to affect this community is very important. And I think, in Texas, we just had our primary. And I recently had a hearing in front of a judge who isn't going up for re-election. So, like, including that in the story was really important, because it was a very complex case. And it's like soon she won't even be dealing with this case. It will be somebody new. So having that included in our stories as well, is something to think about, also. So.
All right, I think we've got time for one more question. I want to ask each of you, what is an example of a story that turned out particularly well, or something that you discovered by virtue of paying close attention to what is going on in the courts? Maybe we can start with Michael.
Sure. I would maybe name two things. First is our State Court of Appeals issues about 1,700 opinions every year. And I might be one of the single-digit number of people who read through all 1,700 opinions. I skim them. I don't read in detail every single one. But because of that, I do notice trends that are happening. And a couple of years ago, the Supreme Court here interpreted the crime victim restitution law in a way that did not match what a lot of trial judges and a lot of prosecutors were doing. So it created this whole new system that had to be adjusted to. And because of that, a lot of crime victim restitution awards got overturned when they were coming up on appeal. And so the state Supreme Court did have to sort that out. It did it in a big package of cases last summer. But before it did that, the state's Court of Appeals had to wrestle with it. And I saw this dissenting opinion, or maybe it was a concurring opinion from one of the appellate judges. And those things are pretty rare enough to the point where I remember kind of where they happen and who wrote them. And he was laying out his disagreement with the state Supreme Court's process for crime victim restitution and what should happen with awards that don't follow the law. And as I was reading it, I was thinking, wait, didn't I just see this? And so I looked back a couple of weeks in my files and I pulled up a different concurrence that judge had wrote in a different case. And it was almost word for word the same thing. The facts of the individual case and the individual criminal defendant were different, but his argument for why the Supreme Court's precedent should be revisited was verbatim. And I am not suggesting he was intending to get media coverage. I think he was just trying to express his honest views about what the Supreme Court did and maybe the shortcomings of that ruling. But the effect was that he did get a news story out of it, and he didn't write any further concurrences. I trust that he got his point across both to the public and to the state Supreme Court. But that wouldn't have happened if someone in my position weren't actively logging what our appellate judges are thinking and the trends that they are manifesting in their own case law. The other thing that's not case related, just really quickly, Colorado has a judicial discipline process for its state judges. I think every state has some version of this, and it wasn't transparent up until the very final stages. Voters changed the Constitution a couple years ago to make it more open earlier in the process, but until it really got to the state Supreme Court, you really had no idea that a judge was being disciplined actively. And so a lawyer emailed me and said, hey, did you know that this judge on this court has been suspended? And I said, no, I did not know that. I have no way of knowing if they're undergoing a disciplinary investigation that would result in suspension. But I did think to email the state Supreme Court and ask for any orders of suspension for state judges, because those do have to be public, unlike the rest of the disciplinary proceedings. And sure enough, the court sent me back an order suspending that judge, and it was at the request of the disciplinary commission. So I did feel like the Jurassic Park moment where the raptors open the door, they like find the trick to get inside. So it was like my way of getting kind of inside the disciplinary process and seeing what was happening in real time. It's not as big of an issue now with the increased transparency, but again, it does take some like critical thinking about like who you're covering, what is available to you, and what can you ask for and actually get a response on.
Alexa?
Yeah, the story that comes in mind for me is when I was in Indiana, and I would sometimes just hang out or just pay attention to, committee hearings at the state capitol. And there was one where it was a family law bill, and I was just I think I was covering like for a different bill, but ended up being there and like listening to testimony for this other case, and that ended up being a very, very beautiful story about this, foster mom who's very much trying to adopt her two boys, and it was a very lovely story, and that was one like I just wasn't expecting to even come across that, and so that has been something I've kind of learned of like just hanging around places and like eavesdropping a little bit, seeing what you'll find, and then ask questions. Always be curious. And, especially like in courthouses and in this position, there's always attorneys just having, fun conversations in the hallways. And, if you just ask them, what are you talking about? You can learn some fun things.
Fantastic. Bob, very briefly, a story of yours that came about because you pay more attention to courts than most people do?
I honestly can't think of much. A couple of things that are just sort of memorable to me are covering the confirmations of U.S. Supreme Court justices who were accused of sexual abuse, Clarence Thomas and Brett Kavanaugh. Particularly with Kavanaugh, I did get to interview the woman who accused him who is a psychology professor from not too far from where we are in Northern California. And I don't know if anyone else interviewed her, but it gave me, I guess, some insights when I saw the votes and saw the accusations and the defense of the justices. I don't know, and I wasn't there. I don't know what to make of it. I found the woman quite credible, but the future justice said otherwise. I just think the story got read and it affected me because every time I see Justice Kavanaugh up there or Justice Thomas or whoever, I guess I think of the people who accused them back in the day. Does that mean that they're not qualified to be on a court? Probably not. If anybody who has seen me at my worst moments, went to my employer and said this person isn't, shouldn't be on your staff. Who knows whether I'd be there or not. But it gives me some context to when I cover their future rulings and the rulings of the institution.
Thank you, Bob. Thanks so
Yeah.
much. Good reminder for all of us. I mean, we're all employed in the law one way or the other, and there's human stories behind all of the law and all of these decisions. And so thank you again. So thanks to this panel for again bringing life to those stories. So Michael, Alexa, and Bob. This was a very rich conversation. All right, with that, I have to turn abruptly in my capacity as Stern time manager to panel number 3, which is our judges panel. And I'm thrilled that we have these 3 individuals coming to share some of their experiences with us. So without further ado, we have Judge John Kane, a senior U.S. District Judge for the District of Colorado. Judge Kane was appointed in 1977, by President Jimmy Carter, and continues to preside over civil and criminal cases alike. He has taught law at the University of Colorado, the University of Denver, and has written and published extensively in various areas of the law. Next, we have Justice Carlos Zamor, who was appointed to the Colorado Supreme Court by Governor John Hickenlooper in 2018. Prior to that, Justice Zamor was a trial court judge, a role he held for 11 and a half years, the last 4 of which he spent as chief judge of his judicial district. Last but not least, we have Justice Tino Cuellar, who is a former justice of the Supreme Court of California. Justice Cuellar has served in 3 U.S. Presidential administrations at the White House and at various federal agencies. He was also the Stanley Morrison Professor at Stanford University, holding appointments in both law, political science, international affairs, and also leading the university's Freeman Spogli Institute. Justice Cuellar is currently the 10th president of the Carnegie Endowment for International Peace. Okay. I will remind the audience that if you have a question for the judges, please drop it in the chat. But I will kick us off. So when you read press coverage of your court or cases that you have decided, what aspects tend to be most often mischaracterized or oversimplified or missing? And what are your thoughts about what more accurate coverage would look like? Maybe we can start with Judge Kane.
Okay. Well, I think there is a paucity of coverage of trial courts, and I will tell you that I've seen one reporter here in the U.S. District Courthouse for the District of Colorado physically present in the last 15 years. And one of the things and that's Mr. Karlik. The other thing that I think is truly, and I don't want to spend the whole time complaining about things, but I think is truly reprehensible, is to think that journalism is satisfied by printing press releases. And that's what we get all the time, especially in the local coverage of a press release, usually from the prosecution in criminal cases, or in large commercial cases. Companies sometimes have public relations departments that send it out. Well, there's a number of things about them that make them inadequate. One is they're written from one position only. The second is they very seldom tell you what the other side's position was. And thirdly, they don't tell you how the judge reasoned. They just tell you that there was a conviction. And they sometimes mention the names of the prosecutors, but frequently the names of the defense attorneys are not mentioned in criminal cases. And in civil cases, it's worse. My view is that I think I'm accurate in saying this, that there are in Colorado 40,000 lawyers. It's not advertising to report on what goes on in the courtroom. It's needed information so that people can know who they should retain and who they shouldn't. They should know more about the artistry of advocacy, and it's hardly ever mentioned. So I think those are the downsides. What I find is that there's just really no coverage to speak of, except I do note the exception to that is Mr. Karlik, who calls and he checks with the clerk's office. There was a man I was very fond of who passed away this last year named Bob Boskowitz, and he was a stringer. And every day he would go to the clerk's office and thumb through to see what the filings were and the opinions and so forth. Another matter is that every day, work day, the 10th Circuit Court of Appeals releases order and judgments, which are not precedent for other cases, and they're usually very brief, and they provide valuable information about the local cases that have been decided. Then they have their published opinions, which are matters of binding precedent for the trial courts. I think a lesson for reporters, a sort of rule of thumb, is that trial courts are focused on facts. They're bound by the law that's given to them by the courts of appeal, and they're also bound by the pronouncements of the Supreme Court of the state and the U.S. Supreme Court. Courts of appeal are focused on law with the idea in mind to keep the trial judges from committing error by not reasoning properly according to established law. And I think, although it's an unfortunate word, I don't mean it in a critical way, but Supreme Courts are focused on what I would refer to as juristic policy, and that is that a broader outline and resolving conflicts among various circuits and conflicts in the law that they have to resolve. So that becomes more a question of wisdom rather than discernment. A trial judge, we don't choose the cases that we want to follow. We follow what we have to. I think that's important. The other thing is that I see very little done in reporting. Sometimes in magazines or journals, there'll be an effort at this, but I see very little that's measuring what I would refer to as the craft of judging. Some opinions are well worth reading because they're beautifully written. Others need a copy editor. And a lot of the stories that we get in the daily press don't cover that. As a matter of fact, we don't know who the judge is. We don't know what was actually said. And frequently, we don't know which court it was in. It's very important if it's a state court or a federal court. It's very important if it's a local case or it's one from another jurisdiction that is being reported upon. And we don't get that. We don't get it at all. That's my answer.
Thank you. Thanks, Justice. So let me turn it to Justice some more with an invitation. If you'd like to elaborate on the point that Judge Kane was also making, whether there are aspects of judging and adjudication that you wish the news would spend more time on, like the artistry of advocacy or the craft of judging. The initial question was, what is often most mischaracterized by legal affairs reporting, in your view?
So thank you for having me. I like what Judge Kane said, and I tend to agree with his comments. And so I echo what he just expressed. In terms of what tends to be mischaracterized in opinions, I think we're fortunate, at least in terms of Colorado state courts, and specifically the appellate courts. Mr. Karlik, does a really nice job of covering the cases that we decide. And, and I know that he has some legal background, and I think that's very helpful. I know that he has a year of law school under his belt, and that comes across in his writing. When I read his articles, when we read his articles, we see that he understands the process, he understands how things work. And so I think we're fortunate that way. If I were to be nitpicky, I guess I would say sometimes I see the headlines tend to not match kind of so much what the actual article is, or tend to sensationalize a little bit. And I get it. You have to sell papers. So I understand. And it may not be Mr. Karlik choosing the headlines. We understand how that works. The only other thing I would say is that sometimes if it's a split opinion and the article mentions the dissent, it sometimes seems to focus a little bit on sort of the disagreement, and then because the article is giving coverage, so much coverage to the disagreement, it maybe takes away a little bit of the coverage from the analysis of the majority opinion, which is really what counts. You have to report on the dissent, of course, if there's a dissenting opinion. But and maybe this is just an attempt to make the article more interesting for the reader, right? I suppose that it's more interesting if, as you're reading, you're seeing sort of the disagreement among the different members of the court, the Supreme Court, in our case here, the state Supreme Court. But that's about the only other thing that I would point out. Sometimes I feel like the dissent comes up pretty quickly in the article, pretty early on, and then he goes back to the majority sometimes. But I feel like it takes away a little bit from what the majority is actually saying, or the analysis. I mean, the articles are accurate by and large, and are thorough, and tell you what the ruling was, tell you what the facts are, what the arguments were, and then tell you what the rulings are. But sometimes it feels like the dissent comes up pretty early on in the article, and it does go back and forth a little bit. And again, that's probably an attempt to make it interesting. That's about the only thing I can think of.
Justice Square, same question. Mischaracterizations that you've encountered of your opinions or your work, what aspects of judging you would wish to see more coverage of in legal affairs reporting?
Thank you, Andrea, and it's really an honor to appear with my fellow jurists. I should add that I am not Emily Sorkin, even though that's what it says. That's the name of my assistant. But I think that the topic we're discussing is hugely important. Let me start, maybe, if I could, Andrea, with what I think goes well in my view, and how many of you cover the courts. And here I'll include Bobby Gelko, who's the senior reporter covering the California Supreme Court. I think when I would often work through a really technical case, like a really intricate case involving some abstruse civil procedure rule, and I was trying to make sense of what it really meant in practice, it would take me a little while to wrap my mind around it. And I would be thinking, of course, about the role of the court, interpreting the relevant materials, but I'd also be asking, if an informed layperson were trying to make sense of why this matters, how did this get up to the California Supreme Court? What would they be saying about this? And for the most part, I think the professional reporters, not the bloggers necessarily, not the lawyers posting a little announcement on their website about what this means for employers, but the professional reporters did a pretty good job of doing that kind of active translation when they covered a case, like how some technical arbitration dispute or civil procedure dispute or issue involving unconscionability of loans, like really potentially affected people's lives. So kudos. I think that's good. In this day and age, like anything that cuts through the smoke is a good thing. Where I think we could do better is one, as my fellow jurists know who have been on a court of last resort, oftentimes the actions you're taking include not only deciding to decide a case and then deciding it, but also a variety of other actions where you decline to review something if a court has a discretionary review. So you can decline to take the case. In the Supreme Court, we call that declining cert. In the context of a state Supreme Court like California, we just call it declining review. We, in California, can do several other things. We can depublish an opinion, which means it stands for that particular resolution of a dispute, but it does not have precedential value. We can grant and hold the case, which means we think it's similar enough to something else, we're deciding that we hold it. Needless to say, where I'm going with all this is that any action other than deciding the case is often a little opaque to report on. And sometimes it's reported on as like, court lets stand blah, 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 or court accepts blah, blah, blah. And that may give the impression that we're endorsing a particular conclusion when we really weren't. We just decided not to grant review. And, when you have 6 million plus cases a year, as we did in California back when I was a justice, and we can take, 100 cases to decide, like you make the decisions for all kinds of reasons. Last quick point, which is a court is an adjudicator of specific cases, but at the top of the system in the state, justices also get involved in helping to run a really complex administrative system that allows judging to actually happen at scale. In California, you have like thousands of personnel, judges, and so on. And I think that it's harder for the media to make an interesting story out of that, even though hugely important, right? Like, how do we deliver justice at scale to millions of people? Not easy to do. Depends on the decisions we make as judges in the cases, but it also depends on budgets, administrative procedures, personnel, hires, decentralization. And I think that deserves more coverage.
Great. Very helpful. So in summary, we need more paying attention to advocacy, adjudication, writing, remedial processes, different dispositional holdings of a case, and the judges have a bone to pick with whoever is writing the headlines. Okay. I've also been instructed by Michael Karlik to say that he did not, for the record, assemble this panel of distinguished judges to compliment him. All right. So more criticism of Michael Karlik in the next questions. All right. No, let's turn to your interactions with legal affairs journalists. So what sort of a relationship have you had during your time on the bench with legal affairs journalists, and what sort of distinguishes, in your view, the reporters who cover courts well from those who struggle? Are there sort of habits of preparation or modes of inquiry that you've noticed make a real difference?
Well, maybe I'll start just very briefly by observing that the very best reporters who cover the courts, and there are some represented right here in this call, I think they don't stop reading after the first paragraph or two of an opinion, even if it takes them a while, and they'll interrogate not only like the issue area, the broad holding, but they'll get a little bit into like the court's holding is narrow, the court's holding is broad, which in fact, thinking back to my years at the court, those are many times the most contentious issues. Like, colleagues might agree that something went wrong at the trial court level and something needs to be reversed, but how broadly and narrowly, that sort of thing. I also think some of the more fruitful interactions I've had with reporters happened informally and off the record over lunch, just to talk through these questions about how the court runs in the background.
If I can speak now, I don't know. I agree. I think that the informal relationships are something that I'm missing out on. It used to be in Denver that there were 2 full-time reporters assigned to the federal courts by the Denver Post and 2 by the Rocky Mountain News, and 1 full-time reporter for Survey's Business Journal. That doesn't happen anymore. They used to stop by and they would ask if something was going to happen, anything that they should be looking at. Judges can't spend time talking about the merits of it, but as an example, I've got an opinion that's going to come out at the end of this week or the first part of next week. It's 130 pages long, and it deals with the constitutionality of Colorado's spending limits on elections. It's been to the Court of Appeals once, and cert was denied by the Supreme Court, and I think it's heading back that way again. It isn't my opinion that counts. It's a very huge public issue. And I think it needs better coverage. One of the things I remember one of the reporters telling me over a beer is that he said the two source rule. You should never report a story about a case unless you have two separate sources. And that goes back to my notion about reporting a press release is just not a productive thing to do. The other thing is that the old-fashioned way of looking at it was in one of the circulars that we had for this session, and that was what happened to the old journalism credo of who, what, where, when, how, and why. And I don't see very many stories that have that in it now.
Just some more. Any thoughts?
Yeah, so two things I would add is, when I was on the trial court, I happened to preside over a lengthy, high-profile trial, and I didn't have any personal contact with members of the media, but I saw them on a daily basis. They were in my courtroom almost every day, and they were reporting on things almost on a daily basis, even before the trial started. So for a period of about 2.5 years. I was familiar with what they were reporting, what they were doing, and I would see them all the time. I remember one of them, the primary reporter was John Ingle, is his name, and he used to be with the Denver Post. And then his wife, someone who became his wife eventually, I believe, Jordan Steffen was another one, also at the Denver Post. And I remember going home at the end of trial, like at 6:30, and driving by the parking lot and seeing John outside his van typing away on his laptop, reporting for that day. He'd taken his shirt off, he had his T-shirt on, and he's just typing away. And he did that every day at the end of the day. So I would say two things that come to mind in terms of what made John and his wife and other folks who reported on that trial were being very involved in the case and knowing the case well. They had studied the case, they had followed the case, they had worked the case from the beginning. And so they were very familiar with the issues. They were familiar with the rulings. They were familiar with the questions that were posed, the arguments that were made. So I think having that kind of knowledge and familiarity really helped the quality of the reporting. That was number one. And number two, is having a neutral stance, right? They're reporting, not offering opinions. And even when sometimes you can kind of, sometimes it's hard to be just 100% neutral, right? And you can see a little, but by and large, I thought they did a really nice job of just reporting on what was happening without showing a bias for the parties, for the judge, for one side, for the other. And so those two things I would mention. I would say the ability to be fair and impartial, and also just really doing the homework and being intricately familiar with the case. Sometimes, reporters make assumptions, I think, about, like, for example, when somebody reports on our opinions, and you'll see something like, in a scathing dissent, just as so-and-so said, and we're like, scathing dissent. I mean, it was maybe, a strong dissent, but, it's not like sometimes if you read the article, you picture that we're throwing things at each other, and that's not accurate. We're actually a very collegial court. And so I think you have to guard as a reporter against that kind of thing, or assuming that, oh, well, this justice was a former prosecutor, so he tends to be conservative, or he tends to be, he tends to go on the side of the DAs or the prosecutors, or this justice was a former defense attorney, so he tends to go the other way. I actually think that in Colorado, on our court, on the Colorado Supreme Court, we're fortunate that, if you look at our decisions, it's hard to find a pattern. Our splits differ. And it's not always the same 3 and the same 4. It's not always, and whether it's civil or criminal. And sometimes we surprise each other where we end up on a particular issue. And I think so you have to guard, I think, as a reporter against making assumptions. So those are the couple of things that I would add.
Thank you, judges. Okay, we have a question from the audience. So this is on rights of access. So Jeannie LaRoe writes, in your experience, what kind of training or other educational support do judges in your jurisdictions get on the rights of access in order to perform your role of evaluating requests to seal records or proceedings or to issue gag orders? Given the critical constitutional and other legal rights at stake, do you feel educational support for judges on these topics is sufficient? Do any of our panelists have a thought on this question?
Well, I don't seem to be shy, so I do agree with what my colleagues have said. So far, I haven't found any reason to dissent. I concur. I will say that I had an advantage in that before I became a judge, the last few years of my practice was representing different organizations, television stations, and the Colorado Press Association, and a few others in lawsuits because of the efforts to close down and make all these things confidential. And I just ingrained with the notion that courts are public institutions, and access to that information in the court seems to me to be neglected and abused at this time. And it's more a legislative function than anything else to do this. But I think a court is a matter of public record, and we have a duty to articulate our decisions and to get them out to the public. And I really think that I guess my bottom line is I think that the present confidentiality and sealing of proceedings is way overdone. Years ago, it used to be that the name of a rape victim would not be published, and the names of juveniles would not be published. I think that there's valid reason for protecting women who are victims of sex crimes. I no longer think that juveniles ought to be protected. I think their parents ought to be published. The names of the parents ought to be published to see all of the things that are happening with neglect and the causes of increased bad behavior because of parental neglect. So I'm kind of a First Amendment freak when it comes to that, but I have to obey the law as it comes out, and sometimes it really sticks in my craw.
Yeah, I would have to I have to agree with Judge Kane on the transparency. I'm a big transparency person. When I handled that high profile case that I mentioned on the trial court, I handled it in accordance with trying to be as transparent as possible. I think that one of the errors that judges tend to make is, when they have big cases, is they push the media away, right? Because they think, oh, that's just going to be an added headache, and I already got enough on my hands. And I just don't agree. I just don't agree with that view. I think that, our courts are the public's courts, not our courts. Our system is the public system, and they're most interested. The public is most interested in the high profile cases. That's what they want to see. That's what they're interested in, and that's when we push the media away. That doesn't make sense. The media is here as the public surrogate, reporting on what happens in the courtrooms, and the public has every right to know. There are exceptions, of course, and Judge Kane mentioned, sex assault victims, and you have to make some exceptions to that. I'm disappointed that the federal system doesn't allow, cameras in the courtroom. I think that they still continue to believe that the concerns outweigh the benefits, and in my experience, it's the other way around. I think the benefits outweigh the concerns, and I think there are things you can do to guard against those concerns. And in terms of what training we do, I know that we have an annual judicial conference. The Colorado State Judicial Branch does every year. And almost inevitably, every year, there is some kind of course on handling high-profile cases. And, part of that involves dealing with the media and welcoming the media and working with the media, as opposed to, issuing orders to gag orders or orders to seal proceedings or things like that. And anytime people ask me my views on the subject, I tell them what I just expressed here and my strong views about the importance of transparency and how critical that is to our justice system.
I agree with my colleagues.
Good for you. I agree.
All right. Well, then let's pick up on the wider theme of transparency, which Justice Sommore sort of broached very eloquently. The notion is that courts have traditionally been cautious about public communication, but it seems undeniable that in the era of social media and 24-hour news cycle, there's sort of greater appetite by the public for access to judges or the way judges think. How do you think about the institutional responsibilities of judges in a sort of, informational environment like this, whether this be trying to write your opinions in plain language, or developing post-argument summaries, or expanding public access to the court and its deliberation it certainly sounds good to say that you're in favor of transparency, but maybe there can be too much. So how do you think about this sort of navigating this line?
Did you want me to go first?
That would be great, Judge Kane.
All right. I would say that one of the biggest problems we have today, and since the visitation of computers on our system, is that a great many lawyers no longer know how to write. And I think that judges are trained as lawyers and develop some very bad habits as lawyers that they have to get rid of. There's an excellent book on legal writing called Strunk, Elements of Style, which most judges that I know read and study. But let me give you an example that happened in a case I had not a couple of years ago, where two experts in psychology, one for the plaintiff and one for the defendant, they both qualified as experts, and their testimony in this regard was in agreement with one another. And that's that they did a study was available that they both examined, where an opinion poll was done of people of ordinary education, asking them to identify what prior and subsequent meant, and 60% could not do it. So getting that kind of lingo of prior and subsequent and here and as and above, forth, and all of that nonsense, we're not wearing spats. We shouldn't be doing that. And the simple declarative sentence, first of all, should be used. And secondly, it should receive attention from the journalists that are reporting to see when they see good writing and when they don't. But some of this stuff is so abstruse that it's just, for want of a better word, I'll say gibberish.
I think you raised a good point that the challenge is not only how does the media cover the courts, it's also what do judges do. And here I agree with Judge Kane. I'll add maybe my version of his comment, which is I tried to write opinions where if you took out every single citation, they would still make a coherent argument and you could still understand, like, what was the logic? What happened here? And I felt like often when the media tried to cover our opinions, if we didn't do that, it was harder. And it felt important to realize that our core audience couldn't be primarily other technical experts. That would be a real risk. And instead, we should remember that our real audience in a democracy like this one were the people who were subject to our decisions, who had to live with the consequences of what we did, the informed lay public, right? I would add that my own thinking changed over the time of my years on the court about how available to make myself for kind of like human interest type engagement. Because on the one hand, I thought I'm part of an institution. It should be a little impersonal, should be a little removed. Who I am, what my backstory is, doesn't really matter that much. Over time, I came to realize that in so much shrill noise about courts and what opinions meant and what the rule of law really was or wasn't, or what counted as corruption or not, one hard fact is that beyond the people who read the professional reporters, the folks who instead get their news from word of mouth or from blogs or from feeds on Facebook or whatever else, like there is so much polarization that you can't expect that people would seek out the objective truth. They'd be influenced by so much noise. And helping the institution be humanized a little bit by having the public see us as real people, without getting into the specifics in case we couldn't talk about. That was sometimes helpful to put into context what we were trying to do. So I did more of that over time. Spent more time just kind of chatting a little bit with local media about like what got me to the court, or going to community colleges and talking to students there, or speaking at graduation events and that sort of thing.
Yeah, I agree with both of my colleagues on the panel. I try hard to write so that the public can understand what we're saying, what I'm saying, and I'm not suggesting that my writing is great, but I do try hard to avoid the legalese and to avoid, I think legal writing is not only difficult to understand for the public, but it's dry and it's boring. And I think we owe it to the public to make it more accessible, to make it more interesting, and so that people can not only understand it, but they want to read it, especially given how long opinions tend to be, right? The least we can do, I think, is to write it in a way that is accessible, to write it in a way that they can consume it and understand what it says and be interested in reading it. And I when I was on the trial court bench, not long after I got into trial court, the orders that I had been used to getting were started something like, the court is in receipt of the petitioner's opening brief, the respondent's answering brief, the petitioner's reply brief, and being aware of the premises hereby declares or orders. And I was like, what does that mean, being aware of the premises? What the heck does that mean, right? And why do we have to say that? But everyone just, this was the way it had been done, and so that's the way you did it. And I just don't agree that having that type of order is useful, and I'm not sure that it serves a purpose. So I pretty quickly stopped using that kind of format. Now, there is a limit, and you asked about the limit in your questions. And there is a limit to access, right? So, for example, it would be improper, I think. It would be unethical for judges to, after they write an opinion, to sit down with the media and talk about why they reached that opinion or what they thought about in reaching that decision. It would be improper for the media to be invited into the deliberations room where the justices are talking about, how they're going to decide a case, right? We can't have that. That would inhibit, I think, the decisions that are made. And so there has to be a limit to access. And you were asking about the limit. And so definitely there are limits. But I would say there still has to be a lot of transparency, and maybe more than what we have right now. And we're really making an effort. That's one of the big things I think that our current chief has been working toward, and the prior chief did as well. We understand the importance of transparency, and we're working hard to make the branch more transparent.
It's encouraging to hear. So we have sort of a statement for maintaining the institutional authority of courts, doing so by legal arguments that make sense on their own terms, that an informed public can understand, right? And at the same time, arguments for the values of transparency and accessibility within reason. Okay. That went really fast. This is sort of, we're at time now. So let me just thank again the panelists for being so generous with their time. I found this discussion enormously enlightening. I hope that the audience did as well. Thank you to Michael Karlik for all his work getting us together here. I'm to remind attendees that if you have further questions, you can follow up with the panelists individually. That includes myself. I'm happy to talk more.